Morning, Hugh.
Good morning. How are you?
Very well. How are you?
Yeah, not too bad.
Good.
Looking forward to the bank holiday.
Yes, well, I'm looking forward to the traffic to and from Scarborough to see my mother, which should not be a fun thing to experience. No doubt I'll spend my life on the A64 on Monday.
Yeah, well, I'm going to go down the M5 and see my mother in Cheltenham.
Yes, assuaging guilt rather than necessarily a special visit.
Yeah. Good. Okay, well, I think you should have got our draft, our closing.
Just printed it off now, so thank you for that. That's really helpful. Mine should be sent to you. It's via Angela, so hopefully it should get to you any moment.
Right. Good. Okay. Well, I will resist the temptation.
As ever, complete trust. Don't worry.
Okay. Good. Okay. Well, I'll see you later.
Cheers. Thanks.
Okay. Cheers.
Good morning, everyone. The time is 10 o'clock and the inquiry is resumed. Hope you can all hear me okay. Good. This inquiry relates to the appeal against the decision of Charnwood Borough Council to refuse an application for up to 170 dwellings at land to the east of Cossington Road in Sileby. Please ensure mobile phones and other devices are switched to silent, please, before we get going. And as usual, unless you're speaking, please switch off your microphone and your video. This is the 7th and final day of the inquiry, and over the course of the last 6 days so far, I've heard from a number of interested parties and witnesses, and also held various question and answer sessions and roundtable discussions. Today, we will hear the closing submissions of both parties. We're likely to only sit for the morning, but I'm happy to take a break sort of later on this morning if needed. And before we get going, I've just a few updates on documents. I've received the Barnard's Drive appeal decision and the neighbourhood plan examiner's report as ID 23 and 24. I see that both are on the website, although I noticed ID 23 seems to be password protected. I clicked on it and it required me to enter a password. So that's the appeal decision. So I assume that's just a technical thing that the council can correct, Mr. Richards.
I'm sure it is. He said without the technical knowledge himself as to how to do it.
Okay. Everything else seems to be unpassword protected, so I assume it's just a setting thing.
Yeah.
Thank you. And then I've received the account. Well, I've now received both closing submissions. So the council's as ID 25 and the appellants as ID 26. And just to check, Mr. Tucker, I received a PDF and a Word version. I assume they're both the same, just in different formats.
They're identical, sir. It's just that I'm mindful that tucked away within the guidance somewhere is the suggestion that the inspector's copy should be a Word version, even if a PDF goes to everyone else. Now, that may be a recollection from call-in inquiries where there's more copying and pasting, if I may put it that way. But in any event, that's the only reason, sir. They're exactly the same.
That's fine. I thought that was the case, but thank you.
Do you want a Word version of mine, sir?
No, I think I'm content to have PDFs. I mean, in a call-in situation, it may be advantageous to have Word, but I think in this kind of case, I think PDFs are fine. So thank you. Are there any other procedural matters from either party before we start, Mr. Richards?
No, sir. Just to note that the closing I'm about to read to you and to the inquiry is also on the website. So if people who haven't had an email copy want to follow along, it's on the website now.
Yeah, and
I haven't checked whether it's password protected.
I think I checked that, and it seemed to open for me when I was checking just now, and I just clicking refresh on the page. It seems that Mr. Tucker's statement is there as well now. Closing submissions there as well, so people can follow that as well.
Good.
Great, thank you. But nothing else from the council?
No, sir.
Just anything from the appellant, Mr. Tucker, before we go?
Nothing else from our perspective, sir. Just the issue of closing submissions.
Okay, fine. Thank you. Well, if there's nothing else from anybody else in this meeting, just checking who else you've got in the meeting. Yeah, if nobody has any other points or questions before we get going, then Mr. Richards, when you're ready, please begin your closing submissions.
Yes, sir, and thank you. And I'm reading from a screen that is slightly off to one side of the camera I'm looking at. So if I'm not looking at you or directly at the camera, you will understand why.
That's fine.
So these then submissions should be read alongside our opening statement, which is ID 3, in the interest of avoiding unnecessary repetition. So by way of introduction then, Sileby is growing. House building is proceeding apace. If the council's strategy and plans come to fruition, it will continue to grow. Its smaller neighbour Cossington is also planned to grow with the blessing of the council. At the heart of this appeal is whether that growth should include up to 170 dwellings on the appeal site, which has long been an area which the development plan identifies as being important to be kept open to assist in preserving the separate identities of the two settlements. Developing the appeal site as proposed is not part of the council's strategy and plans for the area, nor those of the two parish councils, which have or are now producing neighbourhood development plans. The foundation upon which the appellant's case is built is that the council cannot at present demonstrate a 5-year housing land supply. The NPPF's tilted balance is therefore engaged, which means, so the appellant says, the harm to interests of acknowledged importance should yield to the need to increase the supply of housing and the benefits that this would bring. In essence, the council says that the adverse impacts of the proposed development do significantly and demonstrably outweigh the benefits. And of course, the appellant disagrees. So you, having been appointed to determine this appeal, have identified main issues which these closing submissions will consider in turn. And so the first main issue, the effect of the proposed development on the character and appearance of the area in relation to landscape and the area of local separation. And I'm going to first deal with the area of local separation. The appeal site's designation as an area of local separation has persisted in development plans for 25 years plus. The actual gap is shown, the policies map shows the extent of the gap. And it's also shown in the design and access statement. Local plan policy CT4 describes areas of local separation as being already narrow, a planning judgment reached after the examination of the plan, and seeks to ensure that it's not reduced. The dimensions of the gap and the effect of allowing built development as proposed are described by Mr. Higson in his proof, I give the references, and shown on the measured distance plan at ID 11. Although there will be no reduction of the gap between built development at its shortest point, as a result of the proposed development, the ALS will be reduced in depth by between 61 and 160 metres across almost the entire width of the field that comprises the appeal site. The extent of the reduction is further illustrated in the visualizations document, particularly 11 and 12, 15 and 16, and 19 and 20. The open and undeveloped character of ALS remain protected in the core strategy, unless new development clearly maintains the separation between the built-up areas of these settlements. The gap remains protected and unreduced in the Sileby neighbourhood plan. Further housing development has been resolved to be permitted at Humble Lane, which extends Cossington eastwards, and this is illustrated on the updated verified views, which replace those in Mr. Cook's Appendix 4. Whether the separate identities of the two settlements will be maintained will be perceived by, firstly, the local residents of Sileby and Cossington. The evidence that they've provided, both written and oral, is that there will be harm on this count. Next, by users of the public rights of way network, including the Leicestershire Round. Next, by travellers on Cossington Road. Fourthly, by travellers on the railway. And fifthly, by users of what is now an open field of separating gap, which would become a designed, shared, public open space for residents of both Sileby and Cossington. Rather than being a separating feature, it will become a joint space, which Mr. Higson described in cross-examination as being peri-urban, where the sense of separate identity is blurred. All of this will have been carefully noted and considered on the site visits, on the accompanied and unaccompanied site visits undertaken by USA. Now, the reason why the ALS gap is important and protected is well set out in the evidence that predates the appeal. And I quote now from 3 consultants' report. First of all, the Green Wedges, Urban Fringe and Green Infrastructure Enhancement Zones and Areas of Local Separation report by Arup in 2016, added to in 2019. The report was commissioned by Charnwood Borough Council to review the locations and boundaries of green wedges and areas of local separation in the borough. The report noted that ALSD, which you know is the one we're dealing with, provides the gap between Sileby and Cossington, preventing further ribbon development along Cossington Road and ensuring that the integrity of the gap is maintained. The addendum report was commissioned by Charnwood to review and respond to the representations received in response to the consultation on the Green Wedges and Area of Local Separation report, with the aim of assisting their consideration of making or amending designations in the emerging local plan. In relation to ALSD, Arup found that ALSD provides the gap between Sileby and Cossington, preventing further ribbon development along Cossington Road and ensuring that the integrity of the gap is maintained. And Arup did not recommend any alterations to the area of separation following their updated assessment. There's also a report by Luck in February 2021, which we've got at CD 6.09. The report was commissioned by the Borough Council to assess housing sites that had been promoted to the Council through the local plan process in 2019 to 2020. The report assessed the land covered by the appeal planning application and found that it had overall low-medium sensitivity, and the site plays a significant role in retaining the sense of separation between Sileby and Cossington directly to the south. It's important to note that the report presented findings on the overall landscape sensitivity of the site and was not a standalone assessment of the effect on the ALS. And then lastly, the Luck report in July of 2021, CD 6.10. The sites were considered in this report, with those submitted to the Council for consideration for development as part of the regularly reviewed Sheila. The application sites referenced as PSH 474, Cossington Road, Sileby, and assessment of the development proposal was undertaken and concluded that development of this site would have a substantial and critical effect on the purpose of the ALS. It was not considered that the erosion of the ALS could be mitigated satisfactorily. So the Council's case is that there will be significant narrowing of the gap on a broad front. The landscape Charnwood Borough Council consultation response was objects. The proposal would have a substantial effect on the purpose of the ALSD and result in settlement coalescence, notwithstanding the submitted illustrative master plan indicating compartmentalised public space to the southern portion of the site. The site is the last significant area of open rural landscape between the two settlements and is, as already stated, characterised by an open, expansive arable field. The proposal is therefore in conflict with Policy CS11, which seeks to protect the landscape character of the countryside, as well as maintain separate identities of settlements. The proposals do not protect the existing landscape character that is typical for the character of the Soar floodplain. The landform of the site, as it rises to the east, makes it prominent and particularly sensitive to change. The proposal would significantly alter the open rural characteristic and replace it with built form. This would have a significant effect on landscape character and visual quality, as well as the setting of Charnwood Forest as viewed from the east. Mr. Higson for the Council considered the effects of the ALS in section 5 of his assessment at Appendix 1 to his proof, both in terms of actual and perceived reduction. In summary, he found harm under both heads. But it's fair to say that the greatest harm arises in respect of perception. In cross-examination, he rightly accepted that policy CS11, that should be, does not preclude development in the ALS gap, but that a judgment is called for as to whether separation is clearly maintained and the effectiveness of what land remains undeveloped in maintaining separation. Mr. Cook's case for the appellant is that insofar as perceived sense of separation is essentially unchanged. He says, in the light of the above analysis, I consider that the actual physical separation between the two settlements in terms of the shortest distance would not reduce with the proposed scheme in place. The proposed housing would be located in the northern part of the ALS adjacent to Sileby. But this particular part of the ALS performs a role to a limited degree. The perceived sense of separation associated with the gap would not materially change with the proposed scheme in place. The purpose and integrity of the gap would remain with the scheme in place and not materially harmed. The council submits that his focus on the shortest distance is misconceived and demonstrates the flawed nature of his approach. On that basis, the ALS would simply be a narrow band of the width of the shortest distance running east-west. To be fair to Mr. Cook, in cross-examination he accepted that all of the ALS falls to be considered and that it will be reduced in area. So far as the perception of separation is concerned, when faced with the updated verified views in cross-examination, he accepted there would be perceptual negative effects. We submit this still underplays the likely result. In the end, this is a matter for a planning judgment, which you, sir, are now well equipped to reach. In preventing development and I ask finally the question, is preventing development in this gap consistent with the approaches taken elsewhere in other ALS by the council and inspectors on appeal? And you know from the evidence given that the council has granted permissions in other ALSs, but both parties accept that it's a matter of planning judgment in each case. Next, dealing with character and appearance, and there's a landscape statement of common ground which notes agreement as to the methodology, and that in the National Character Area 69, Trent Valley Washlands, the strategy of conserve and enhance applies. There's a dispute between Mr. Hickson and Mr. Cook as to whether the appeal site is part of a valued landscape for the purposes of NPPF Para 174A. Whether or not land is to be regarded as being part of a valued landscape is a planning judgment. It's agreed that the appeal site is not subject to a national designation or a local development plan designation. In exercising that judgment, Mr. Hickson explains that he has had regard in particular to the Landscape Institute's GLVIA and importantly its technical guidance note 2 of 21, which Mr. Cook did not consider until his rebuttal. He explains why, after acknowledging that the NCA and the National Character Area and Local Character Area assessments report a generally medium landscape value, he finds that local variations present on the appeal site and its local setting cause it to be elevated to a valued status. There are clear physiographical interest, setting to the heritage assets and the contribution to the separation of Sileby and Cossington, and the harmonious combination of scenic components, including the farmland function of the landscape. Although challenged in cross-examination, he was not shifted from his view, which we submit is the correct judgment to reach. But whether the appeal site is part of a valued landscape, which falls to be protected, or is not, in which case it falls to be recognised, there is a huge difference between Mr. Cook and Mr. Hickson as to what the effects of the development will be. Both Mr. Hickson and Gulby and Luck, the authors of the LVIA which accompanied the planning application, assessed the impacts at site and site setting level, as well as against the LCA Saw Valley and the NCA Trent Valley Washlands studies. Overall, they found a negative or harmful effect. But Mr. Cook assesses the effect will be positive or major beneficial for a landscape of which the baseline condition is not in any way distressed. This is an unusual conclusion, to say the least. The National Character Area Assessment includes arable areas as part of its key characteristics, and that cereal farms form 25%. It advises that development should avoid valley floors and bordering slopes, which we submit includes the appeal site. The Local Character Area Assessment advises that development should be directed away from prominent locations on the valley slopes, which again we submit includes the appeal site. All this was accepted by Mr. Cook in cross-examination. So we submit that it's evident that there will be a change in the character of the landscape from an arable field on rising ground to a mix of urban built development and public amenity space. The character of the land separating the two settlements will change from agricultural, which is typical, to peri-urban, which is not. This change will not be in accordance with a landscape strategy of conserve and enhance. Similarly, we submit that the visual impacts will be adverse. Appendix 2 to the landscape statement of common ground sets out the assessments of Mr. Cook, Golby and Luck and Mr. Hickson. Once again, Mr. Cook contends for beneficial effects, whereas the other experts largely contend that should be for adverse impacts of varying degree. In the final analysis, you, sir, will reach judgment. For the reasons given, if the appeal site is not to be protected as a valued landscape, then at the very least, the impacts need to be recognised in the planning balance and given due weight in accordance with the harm that will undoubtedly arise. And as you know, sir, the Council submits that the weight given should be significant. The next main issue I turn to is whether the proposed development would be in a suitable location, having regard to the development plan and national policies. And conventionally, I start with the development plan. And I set out in paragraph 26 what it comprises, which you know is the safe policies of the local plan, the core strategy and the Sileby neighbourhood plan. The parties have identified in the statement of common ground the policies identified in the reason for refusal and discussed them in their evidence. They are as follows. Firstly, CS1, the development strategy. This policy sets out a growth hierarchy for the borough that sequentially guides development towards the most sustainable settlements. So identifies Sileby as a service centre, a settlement that has access to a good range of services or facilities compared to other settlements. For development management purposes, development is supported in the sense that it requires a positive response at service centres, which is sustainable development and which is in accordance with other policies in the plan strategy. Mr. Gould notes that in terms of CS1 strategy, in the period between the base date of 2011 and the latest full monitoring period of the 31st of March 2022, approximately 4,460 homes have been committed within service centres. This is 45% more homes than planned for in the core strategy for service centres. Moreover, of the 4,460 homes already committed, 1,060 of these are at Sileby alone. In terms of the strategy, therefore, service centres have been playing their full part in meeting housing need, and so has Sileby. 3,000 was never intended to be a ceiling, but the minimum has been far exceeded. Its non-delivery in other parts of the strategy, particularly at the sustainable urban extensions to higher order settlements, that have resulted in the current 5-year housing land supply shortfall.
Mr. Richards, sorry, just to interrupt you. I think you said the full monitoring period 31st of March 2022, but it says 2021 on your.
Yes, sorry, I was just thinking we're about to get the monitoring period from 2022 later today, but in fact it's the 31st of March 2021 that Mr. Gould was quoting from.
Yes. Okay. So I don't need to change that. On the...
Yeah. No.
Fine.
Sorry,
okay,
so,
thank you. Sorry.
My mistake.
Okay. Thank you. Please carry on.
Yeah. So paragraph 29, and I turn to CS11, which is headed landscape and countryside, and it seeks to maintain separate identities of settlements. The policy advises that it's intended to protect the predominantly open and undeveloped character of areas of local separation, unless new development clearly maintains the separation between the built-up areas of these settlements. It's agreed that both physical and perceived separation fall to be considered. And ALS have been a feature of plans in Leicestershire since 1979. Local Plan CT4 sets out the policy context for the areas of local separation identified on the policies map. The policy states that on such areas, development will be deemed acceptable, where in the location, scale and design of the development would ensure that, firstly, the predominantly open and undeveloped character of the area is retained, and secondly, the already narrow gap between settlements is not reduced. However, where there is any difference between the policy approach in CT4 and CS11, then CS11 prevails. CS11 also provides the approach to protecting the character of the landscape by taking into account local character assessments. Local Plan CT1 defines which type of development are acceptable in principle within areas of countryside and seeks to prevent significant adverse environmental impact. It's agreed that in this context, both need to be read having regard to NPPF paragraph 174. Neighbourhood Plan Policy G2 provides that development which would have a significant adverse effect on the character of the countryside will only be permitted where any harm is clearly outweighed by the wider benefits of the proposal. Local Plan ST2 limits to development sets out limits to development for settlements within Charnwood. They are updated at Sileby by Neighbourhood Plan Policy G1, which states that outside of the defined limits, development will be, quote, carefully controlled in line with local and national strategic planning policies. Save for development associated with agriculture, the provision of formal recreational sport, and finally, the provision of affordable housing through a rural exception site. So in principle, we say further housing development at Sileby is not contrary to the strategy for the area. The fact that it's proposed outside but adjacent to settlement boundaries or limits of development is not in principle fatal, given the lack of a 5-year housing land supply, but they were set having regard to a housing requirement that's not up to date. But the council says there would be harm arising from the adverse effect on the perception of separation of Sileby and Cossington, together with harm to landscape character and harm arising from visual impact, which means that the proposal should not be regarded as being in accordance with the development plan taken as a whole. Turn to national policies. Identifying ALS in a local plan is consistent with the NPPF. The approach to landscape protection, in this case for any valued landscape accepted by user, and recognition for landscape that is not within the valued category at NPPF paragraph 174 is well understood. There is no difficulty with reading and applying development plan policy accordingly. The Sileby neighbourhood plan is now more than 2 years old, so NPPF paragraph 14 no longer applies. And the NPPF's important presumption in favour of sustainable development is considered under the final main issue below. Next, the emerging Charnwood local plan. The council submitted the emerging Charnwood local plan to meet the needs of the borough until 2037 for examination in December 2021. It's agreed that its policies attract limited weight in this appeal, and so they've not been considered in detail. Sileby remains designated as a service centre, which are collectively to accommodate 14% of the housing to be delivered over the planned period. That's at least 2,747 units, and which have a track record of delivery. 6 sites have been allocated at Sileby, totaling 345 dwellings, the largest of which have resolutions to grant planning permission, and 1 site, known to the inquiry as Humble Lane, at the neighbouring settlement of Cossington, with an allocation of 124 dwellings, again for which planning there is a resolution to grant. This last allocation also identifies an extension to Cossington Primary School to meet the education needs of new developments in Sileby and Cossington. The rationale behind this local strategy is explained in the topic paper behind it, and I give the reference. The appeal site, known as PSH 474, was considered but not selected. However, this part of the borough will continue to play its part in meeting the need for housing through the plan-led system by development to the north, east and east of the village of Sileby. Expansion to the north, west and south is constrained by policy relating to flood risk and the continuing need, as the council sees it, for the areas of local separation, which it is proposed to be expanded to the west. So in the emerging local plan, the appeal site remains part of a designated ALS under policy ENV3. It's not one of the sites identified for allocation for development, The predominantly open and undeveloped character remains protected, and the physical and perceptual separation between built-up areas is to be clearly maintained. Ms. Smedley confirmed in cross-examination that there are outstanding objections when it comes to the continued inclusion of the appeal site within the ALS. But given that the appeal site is now within the ALS in the adopted plan, means that it is not important to give weight to the continued inclusion by policy in the emerging local plan so far as the council's case is concerned. The next main issue is whether or not the proposed development makes adequate provision for affordable housing and other infrastructure requirements. The short answer is yes, as Ms. Smedley famously agreed, and quite correctly agreed in cross-examination yesterday. Next, there's an agreed list of updated conditions discussed at the inquiry. The planning obligation is also in an agreed form. The heads of terms were proposed before the application was determined, and those requested were set out in the officer's report. They've been discussed and refined during the appeal process. There are issues between the County Council and the appellant over education contributions that remain to be resolved, and you, sir, now have all the necessary information to be able to do so. The same applies to the issue between the clinical commissioning group and the appellant over the healthcare contribution. The planning obligation continues the usual blue pencil provision, but sir, please note that it requires you to record that all obligations meet the statutory tests in Reg 122 of the SIL regulations. There is no default assumption that they do. If any individual obligation is subject to your blue pencil, this will not affect the validity and enforceability of those that are found to be Reg 122 compliant. So far as the planning authority is concerned, the conditions on any grant of planning permission and the terms of the proposed planning obligation will ensure that adequate provision will be made for affordable housing and other infrastructure, subject to the resolution of any outstanding disagreement between the appellant and the County Council, and will overcome the second reason for refusal. And then I turn to the last main issue. And I've left it, I'm not sure that it was actually your last main issue, but I've left it till last as it seemed logical to me.
That's fine.
And that is whether or not any conflict with the development plan and harm arising is outweighed by other considerations. This main issue is couched in terms of the NPPF's presumption in favour of sustainable development. The tilted balance in paragraph 11D2 is agreed to be engaged. The council can only demonstrate a 3.34-year supply. This was acknowledged at the time of the refusal of the application, and the housing land supply position is about to be, or has very recently been, updated to a 3.23-year supply. The adverse impacts that fall to be considered are the area of local separation impacts, which are disputed and I've already discussed above, the landscape character appearance impacts, again disputed and discussed above, and the loss of best and most versatile agricultural land, which is agreed in the Statement of Common Ground. The benefits agreed are the provision of market housing of up to 119 units. This is a matter to which Mr. Gould ascribes significant positive weight. Provision of 30% affordable housing, that's up to 51 units. This is a matter which merits significant weight. The development is at a service centre and within walking and cycling distance of a range of services and facilities, and this includes primary schools. The economic benefits, Mr. Gould in his proof gave it limited weight, but in all evidence he described it as moderate. And then the biodiversity net gain, which Mr. Gould gave moderate weight. Some benefits are disputed, whether as a matter of principle or of weight. The new green infrastructure for existing residents. Mr. Gould explains his reasons for giving it moderate weight. Landscape improvements by planting on the proposed open space are not accepted as a significant benefit, nor are the claimed improvements to the settlement edge. So you've had the benefit of considering the current settlement edge on the site visit. The separate benefit claimed by locating housing development within walking distance of primary schools, we say is double counting, and it's already been counted as I set out above. The appellant and the planning authority disagree as to whether the adverse impacts significantly and demonstrably outweigh the benefits. But in that context, Mr. Gould acknowledges that restrictive policies should not be applied too robustly. Axiomatically, the outcome of this main issue depends on a series of planning judgments. The adverse impacts need to be identified and the benefits. But although there are undoubted benefits in adding to the supply of deliverable sites for housing, it's highly relevant to consider in finally fixing the weight to be attached to them for how long the undesirable state of affairs of a sub-5-year housing land supply position is likely to persist. If the answer is not long, and the authority is actively addressing the matter, then we say the benefit of further adding to the housing land supply would be deserving of less weight than if the answer is ages, and the authority is not taking any meaningful steps to address the issue. There are two strands of action that have been taken by the council. First, the council has submitted a new local plan for examination. It contains, as one would expect, allocations and policies to meet the up-to-date housing need of the borough in the period 2021 to 2037. When the examination of that plan is concluded, there is no reason to doubt that the council will, once again, be able to demonstrate the required 5-year housing land supply. Well, when will that be? There are a number of hypotheses. The local development scheme forecasts December 2022 or January 2023, and it's fair to say that this has not survived the scrutiny of the inquiry process. Mr. Gould opines that this is unlikely to be achieved. That's the December or January date. In his estimation, May 2023 is a more reasonable and achievable timeframe. He accepted in cross-examination that there was a range of reasonable opinion on this issue, and it could be later. Miss Smedley expressed her views in cross-examination. I've noticed Mr. Tucker's disappeared. Does that mean he's disappeared or just turned his camera off?
I think he's still there. The camera is.
Oh, that's fine. I don't need to see him. I was just wondering if he'd had a malfunction. That's all right. So I'll go back to paragraph 52B.
And apologies for interrupting, Mr. Richards, by my being handed a cup of coffee by my lovely assistant. Sorry about that.
Yeah, that's fine. So where are, yes, 52B, Mr. Gould's opinion. He accepted in cross-examination that there was a range of reasonable opinion on this issue and it could be later. Miss Smedley expressed her views in cross-examination. She was not invited to do anything other than offer a critique of Mr. Gould's hypothesis in evidence in chief. Her view is the examination is underway, oral hearings are fixed for and are likely to take place in June and July 2022. It would be reasonable thereafter to expect the inspectors to recommend main modifications for consultation. And on the basis that no further oral hearings were required, the inspector's final report could be expected, allowing adoption in 12 months' time. The plan would therefore be adopted in line with Mr. Gould's assessment. However, if, as part of the main modifications, new sites not previously identified were required, either to meet local need or to meet unmet need in Leicester, then further hearings might well be required, and this would be likely to delay adoption by a further 6 months. She did not offer any alternative hypothesis in cross-examination. In re-examination, it was suggested to Miss Smedley that the examination of the plan might suffer a much more lengthy delay, akin to that at Cheshire East, Warwick or Stratford. But in that sort of case, there was a serious issue over the nature of and basis for the housing need and requirement figures, the sort of issue which the standard method assessment of need was introduced to avoid. Miss Smedley was not able to point to anything sufficiently specific. So the evidence is that the range of reasonable opinion for likely adoption within 12 to 18 months. This means that in the planning balance, it is a material consideration to take into account that the undesirable current state of affairs in which the council is unable to demonstrate a 5-year housing land supply is likely to persist for another 12 to 18 months. The second action the council has been taking is to grant planning permissions, or resolving to do so, on windfall sites, and in particular on sites identified for allocation in the emerging local plan. It's quite clear that the cause of the housing land supply problem is the failure of the allocated SUEs at strategic settlements to come forward when planned. However, developers are now on site at 2 of the 3 SUEs, which are expected to give rise to completions in the housing year just started. Significant progress has been made at the 3rd SUE, planning permission has been issued, and development is estimated to begin in the 3rd quarter of 2022. So there is some confidence now that the SUE strategy is at last bearing fruit. It is accepted that if granted permission, the appeal side would be likely to deliver completions within 5 years. A national house builder with a proven track record is on board, which is willing to accept a truncated timescale for the submission of reserved matters. But these completions will come after the adoption of the emerging local plan and alongside delivery at the SUEs and the allocated sites at Sileby and Cossington. So our conclusion, put shortly, is as follows. The proposed development is contrary to the development plan taken as a whole. This is the starting point. However, the tilted balance is engaged, indicating that planning permission should be granted unless the adverse impacts significantly and demonstrably outweigh the benefits. There is a current shortage of deliverable sites for housing. That situation will not be remedied until the emerging local plan is adopted. But the appeal site has been kept open and undeveloped as an area of local separation for many years and through many iterations of the development plan. And so we contend that it is not the site on which to develop in response to a short-term need for additional land for development. In this case, the adverse impacts do indeed significantly and demonstrably outweigh the benefits. And accordingly, sir, we submit that the appeal should be dismissed.
Thank you, Mr. Richards. And thank you for clarifying that point I had as we were going along. But I don't have any other clarification points reading through, so thank you for that closing submission. Mr. Tucker, are you happy to begin straight away with your closing submission, or would you like a short break?
Entirely in your hands, sir. Happy for a 5-minute break or happy to carry on, whichever's easier.
Should we just have a 5-minute break just so I can go and retrieve the printing that I think I've left on the printer, if nothing else. Yeah, so if we adjourn, so we say come back at let's say 10 to, so 10:50 we'll resume.
Yes, sir. Thank you.
Thank you. Right, hello everyone. It's 10 to 11 and so the inquiry is resumed. And unless there's anything before we hear from Mr. Tucker, then Mr. Tucker, please begin with your closing submissions for the appellant.
Thank you, sir. So you'll see my closing is a little longer than my learned friends, although my fonts are larger and my line spacing is larger, so hopefully it won't be too much longer.
Okay, thanks.
So I intend to stick to text, but there are 3 occasions when I'll deviate from text. When I do, I'll indicate, sir, and then obviously I'll tax your pen on those occasions.
Thanks.
So the case that the appellant has to meet in this case is comparatively easily stated. Whilst the council can't demonstrate a 5-year land supply and the council has no prospect of addressing that deficit in the near future, nonetheless, it is said that the impact upon the character of the area and the diminution of the land designated as area of local separation together comprise significant and adverse harm to outweigh the tilted balance. One might even say that this is a case where the resolution of the differences between the parties is one that's sufficiently straightforward that it really comes down to whether you on site conclude that Mr. Cook or Mr. Higson are right that the separate identities of the 2 settlements will or will not be unacceptably eroded by the development. So whilst we are very confident that the judgment on site vindicates the approach of Mr. Cook, we firmly submit that there are a number of important points by way of initial overview, which together mean that Ms. Smedley is absolutely right that this isn't a marginal case, but one where the adverse impacts come nowhere close to displacing the tilted balance when the benefits and harms are properly weighed and then put into the metaphorical tilted scales that you have sitting in front of you, sir. So the following big points are worth stressing by way of initial overview, therefore. 1. The tilted balance is engaged because the council can't demonstrate a 5-year land supply, and also because assessed properly, the most important policies for the determination of the appeal are also out of date. 2. The out-of-datedness of key policies and their geographical expression in settlement boundaries is of relevance when assessing the weight to be afforded to any conflict with such policies. 3. That's not just true of the settlement boundaries, both the 2004 version and the updated by planning permissions version in the neighbourhood development plan, but also the boundaries of the AOLS, the area of local separation, whose extent the core strategy expressly expects to be a balance between housing need and the policy objective. 4. So I should say, sir, that footnotes I tend not to read out, but so they're just really there for your reference when you come to reread the closing submission and write your decision. So the out-of-datedness of boundaries is evident from 4 points. Firstly, the grant of multiple permissions beyond settlement boundaries in the AOLS. Secondly, the fact that they're based on development needs which have long since been superseded. Next, that they are subject to review in the emerging local plan. And noting, sir, of course, that the neighbourhood plan was not such a review. And then finally, the reason why they're out of date is they haven't worked to allow sufficient land to be brought forward to meet the minimum requirement of government, i.e. 5-year land supply requirements and affordable housing needs. So my 5th big point is that despite Mr. Gould's abundant but not infectious optimism, there is no prospect of the current deficit in housing needs being remedied by the imminent adoption of an emerging local plan. In reality, an adoption in early 2024 seems optimistic. The only way to meet immediate needs is the grant of permissions for more difficult sites, such as Humble Lane, as was said to you yesterday, sir. 6. The site is currently an arable field, which reads as peri-urban, urban fringe environment, and is heavily influenced by the existing urban area, particularly the north. The appeal site lies immediately adjacent to, but outside the existing limits of development, with residential development to the north and to the west, and it's therefore as close as practically possible in terms of proximity to the settlement itself and the services within the settlement. The allegation of an impact upon landscape character is difficult to understand looking at that factor, therefore, especially when coupled with the extensive proposals in respect of the 5.88 hectares of public open space, which you'll remember, sir, is about 58% of the appeal site area. 7th big point, sir, the actual sense of separation, i.e. the sense of leaving one settlement and arriving at another, will in no way be diminished by the development of the appeal site. Indeed, it must be a rare case where the principal way in which that separation is experienced is along a road connecting the settlements, and the development which is said to comprise the gap lies well to the north of the road sign, which announces the arrival at Sileby, heading north, and is nowhere near to the closest actual narrow point of the gap. CS11 isn't breached, and the sense of departure and arrival between Sileby and Cossington just isn't compromised in this case. And even if it was, then the meaningful part of the gap isn't just retained, it's strengthened in exactly the sort of way as is proposed to the south of the brook by the north of Humble Lane. So, as we submitted in opening, sir, whilst change in the form of developing a greenfield site may be unwelcome to some, in reality, there simply is no harm that would come close to justifying a refusal of planning permission in this case, and certainly not amount to a very good reason to displace the tilted balance. On the contrary, the appeal scheme will provide a new high-quality residential area with a huge area of public open space in between, which can accommodate extensive planting, hedgerow, restoration, together with different areas of formal and informal recreation for existing and new residents of the two settlements. It will complement the area of open land proposed to the north end of the Humble Lane scheme, and it will reinforce the separating point of the wooded brook between the settlements in perpetuity. Sileby's settlement pattern and identity would obviously remain and prevail with the scheme in place, and certainly you'll recall, sir, that officers thought the design and appearance of the appeal scheme was comparable to Sileby. So section 38(6) of the 2004 Act requires an overall judgment regarding whether the proposal is or is not in accordance with the development plan taken as a whole. Our firm submission, sir, by way of overview but by closing, is that in this scheme it is in accordance with the development plan read as a whole, and the appeal proposal should be approved without delay and substantial planning benefits realised as soon as possible. And that's especially since the settlement boundaries and the extent of the AOLS are in obvious need of review. And even, sir, you will recall that Mr. Higson conceded that there was some capacity for residential development within the site, i.e. conceded that there was capacity within the AOLS. So as this is a case in which the tilted balance applies, it follows that we say the balance is markedly in favour of granting permission for the appeal scheme. And that's irrespective of the section 38(6) point. So turning to the reasons for refusal. So the council posited two reasons for refusal. The first concerns landscape matters and alleges harm arising from the loss of the AOLS, impact to character of the countryside and the separate identities of the two villages. The second, as you know, sir, concerns whether adequate provision is made for open space, affordable housing, etc. So from the council's perspective, the latter, the second reason for refusal, is rightly accepted to be resolved by the section 106, and the former, the first reason for refusal, is the only basis upon which it invites dismissal of the appeal, and that's despite Mr. Gould and Mr. Higson's flirting with issues which don't arise from the reason for refusal, such as conflict with the core strategy itself, and valued landscape, which appears to be a clear case of mission creep. So turning to the issues arising from the first reason for refusal, Mr. Cook's compelling evidence, we say, firmly establishes that on landscape and visual grounds, there are no substantive reasons for refusing planning permission. From an urban design perspective, the appeal scheme, both the built and the POS elements, would deliver a quality scheme accepting the fact that the scheme currently is an outline, and so that's subject to the parameters plan that we discussed on day 3. And so it's consistent with meeting the need for new and deliverable housing, including 51 affordable houses, and the overall objective of preserving the separate identity of the two settlements. So viewing the appeal scheme in context, so it comprises residential development and substantial green infrastructure, which will most likely take the form of naturalistic rural parkland, although of course the actual form and detail is for the reserved matter stage. The local character area washes over the settlement, and the settlement assists in defining the key characteristics of the locality. In the officer's report under the heading Design and Appearance, when addressing CS2, officers note that the illustrative scheme is rightly comparable to the existing built environment of Sileby, and policy CS2, you'll note, so doesn't feature in the reason for refusal. The introduction of residential development in this location is therefore neutral rather than adverse in terms of character, which was patiently explained by Mr. Cook, and so was the reason why he took the view that he did. So his evidence demonstrates that the appeal scheme properly provides, the opportunity to create an appropriate area of open space, which will consolidate the sense of separation. In his view, that's best achieved by this notion of naturalistic parkland, created against the baseline position of an arable field with planting and hedgerow restoration, which reflects the guidelines in the published landscape character area. This results, in his view, sir, in a clearly beneficial effect. That's the logic of his conclusion. And residential properties are, sir, pulled back from the eastern boundary to the railway and the southern boundary, and that's reinforced by replanting conifers and replacing ash trees, showing decay because of ash dieback. So then dealing with effect on landscape elements which define the character of the site. So the appeal scheme will secure the minimal loss of hedgerows to create an access and will reinstate historic hedgerows. It would consolidate the existing and restore former lost hedgerows, and the significant net gain of trees will be a major beneficial effect, with no trees at all being removed to facilitate the scheme and substantial tree planting proposed. In fact, this substantial tree planting would patently create a stronger sense of enclosure to the southern parts of Sileby and reinforce the perceived sense of separation between the settlements, as so you will have seen the effect of the trees at the moment do. So while some arable land will be lost, this resource is ubiquitous and commonplace in the locality, and the creation of small meadow fields results in a major beneficial overall effect. Grassland creation is consistent with the character of the area of separation west of Cossington Road and the proposed POS associated with the Cossington scheme. That's the Humble Lane scheme. This is entirely consistent with the approach to POS for Clarendon Road and Humble Lane. In terms of topography here, there will be no material change and the legibility will prevail with the scheme in place. So as the site is currently in private ownership, the substantial recreational space created with naturalistic parkland is a major benefit. A moderate benefit is provided by the surface water attenuation area as a water feature. So turning beyond the site to the landscape beyond it, well, no off-site works are required to enable this site to come forward, and so the physical character of the fabric of the landscape beyond the site wouldn't alter. All the key landscape characteristics identified in the NCA produced by Natural England would remain and prevail with the scheme in place. The appeal scheme will in fact reinforce the local characteristics of settlement pattern, confining villages to the rising ground at the edge of floodplains, and urban extension prominent in larger settlements along with modern housing. That's the characteristic now, sir. The appeal scheme will deliver multifunctional green infrastructure in accordance with the strategy set out in the Statement of Environmental Opportunity within the NCA. There won't be any changes to the key characteristics of the NCA beyond the site. At a local level, the appeal scheme reinforces visible built development on well-defined rising slopes, i.e. a key characteristic of the Soar Valley landscape character area. There would be a negligible degree of effect upon the wider landscape of the Soar Valley. So moving from that, sir, the character appearance issue to the effect on the AOLS, actual and perceived. So the purpose of the AOLS is to define the actual separation between the settlements and capture the visual dimension of separation, a perceived separation, which of course can only be appreciated by members of the public on the ground passing through the area. As Mr. Cook's evidence demonstrates, the site presently has a very limited role in achieving the purpose of the area of local separation, owing to its physical and visual containment. In terms of actual separation, the appeal scheme would not result in a diminution in the distance between the southernmost point of Sileby and the northernmost point of Cossington, identified by open undeveloped land with a narrowest gap of 150 metres. In visual terms, the site does not play a material role in the principal lines of sight across the AOLS from the public vantage points. And having examined the gap from local public highways and rights of way, Mr. Cook's evidence is that in terms of the area proposed to accommodate the appeal scheme, this part of the ALS provides a somewhat limited role in maintaining the perceived sense of separation between Sileby and Cossington. So by accommodating the appeal scheme, I of course mean the built form of the appeal scheme. So the appeal scheme would not materially change the perceived sense of separation between the two settlements, nor reduce the narrowest gap. The planting within the open space would actually assist in consolidating the separation of existing communities and complementing the planting around the brook, which is a point which is stressed, you'll recall, sir, by the Arup report as an important element in achieving the separation between the settlements. So it's important to understand precisely what policy CT4 requires. That's a permissive policy based on two criteria: retaining the predominantly undeveloped character of the area and not reducing the narrowest gap. It's important to note the first criterion relates to retaining character and isn't a blanket prohibition on development, nor a requirement to keep sites free from development. It was explicitly agreed by Mr. Gould that compliance, as with CS11, requires a judgment, and that you shouldn't, sir, take CT4 nor CS11 as an absolute preclusion. Both criterion of CT4 we say are met by the appeal scheme, and there isn't a conflict with it. And so the council have previously acknowledged that development can encroach into the AOLS and yet still accord with CT4, and I give you the references there, sir. Ms. Smedley's evidence explains that CT1 relates to development on land outside of the limits of development with restricted criteria similar to those found in the Greenbelt policies. Consistently with CT1, consistently with CT1, the CT1 relates to development on land outside of the limits of development with restricted criteria similar to those found in the Greenbelt policies. Consistently with CT1, 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 consistently with I'm just trying to work out whether inconsistently is a typo or whether it should be inconsistent with CT1. Let me just reread that sentence, sir. So I think it should probably be that if you delete the words inconsistently with, then it makes more sense. Apologies. It's amazing how many times you can read a closing submission and still miss things of that nature.
Okay.
So policy CT1 represents an outright ban on open market housing within the countryside, green wedge and open separation. It has a direct effect on the supply of housing and treats all of those areas as if they comprise valued landscape in NPPF parlance. Which does then, sir, inform me that I think the words were meant to be inconsistently with NPPF. But if you can read that sentence together with the next. So it treats all of those areas as if they comprise valued landscape in NPPF parlance. The NPPF is in fact more permissive of development in the generality of the countryside, and CT1 does not reflect this position. As such, Ms Smedley rightly considers CT1 to be inconsistent with NPPF, and it was agreed to be out of date when those points were put to Mr Gould. CT1 also reflects limits to development of the 2004 local plan derived from the structure plan housing requirements adopted as recently as 1994, which are of course agreed to be out of date. So it must follow that CT1 cannot be treated as up to date on this basis. And therefore, so only limited weight can be afforded to policy conflict with it. So the council seemingly accepted that limited weight can be attached to CT1 because they've allowed a breach of CT1 on numerous occasions, approving residential schemes on land outside defined limits to development. So CT4 is of course intrinsically linked to CT1, with CT1 setting out those uses that would be acceptable in principle, the limited ones, and CT4 adding further detail regarding how developments acceptable in principle through CT1 will be permitted. The policy also defines the AOLS, with the appeal site lying within ALSD in a manner which we say is also inconsistent with NPPF. In common with CT1, and that's adding the two together, so in common with CT1, the council have allowed breaches of policy CT4 by approving numerous residential schemes within various AOLSs, as well as having previously considered CT4 as a policy restricting supply of housing and reducing the weight to be afforded to it, for example, in the Melton Road scheme. Rather oddly, in this appeal, it's alleged that CT1 does not have a direct correlation with the supply of housing and is therefore given significant weight, at least initially, by Mr Gould, and that makes no sense. Policy CT4 would, in that context, read with CT1, represent an outright ban on open market housing within the area of local separation and would therefore be highly relevant to the supply of housing. So I then quote a quotation you've now had to put to you a number of times, including by Ms Smedley reading it out from the Rothley case. I commend it to you, sir, but I don't read it unless you want me to do so. Thank you, sir. So the inspector in that case also considered proposals were contrary to CT4 at first blush, but when considered more closely, it was apparent the scheme would maintain an adequate area of separation between Mount Sorrel and Rothley, i.e. applying a judgment. That inspector, considered the AOLS in that case as having a strategic role whose main purpose is to prevent neighbouring settlements from merging or coalescing, adding that if the analysis is correct, there is no breach to that purpose of CT4 other than a technical breach related to the control mechanism of an outright ban and would give little weight to be attached to it. So the only reason I've kept those parts in closing, just for your note, is because self-evidently the council have conceded that CT4 requires a judgment, but you'll recall, of course, other parties have said no, it's in breach of CT4, and therefore that comprises a ban, and that has been an approach advocated in early appeals. That's the only reason why I've left those parts in the closing, notwithstanding Mr Gould's concession.
Okay.
So the successor policy to CT4, CS11, is more explicit about what's agreed to be implicit in CT4, in that it allows a judgment to be made as to whether new development clearly maintains the separation between the built-up areas of the settlements. That judgment is not one that can simply be made by looking at a plan. It's much more nuanced, requiring both qualitative and quantitative factors to be considered, and most importantly, a judgment to be formed on site. So the supporting text to CS11 at paragraph 7.15 says, that the retention of ALS will be balanced against the need to provide new development, including new homes, in the most sustainable locations. An exhortation to decision makers, sir. CSL 11 acknowledges a balance needs to be struck, and in this case, there is a need to provide new homes. The council's unable to demonstrate the required supply, and Sileby is agreed to be a sustainable location. The balance, therefore, lies in favour of delivering homes on that part of the site which has a capacity to accommodate homes without harm to the overall character and area and the function of the AOLS. CS11, sir, seeks to protect the undeveloped character between settlements, but the retention of such AOLS as the undeveloped land needs to be balanced against providing new homes means that it's long overdue a proper review to see where the proper balance lies. So whilst the council disagree, and whilst they consider the policy to be broadly consistent with NPPF such that it can be afforded significant weight, that's ironically inconsistent with their case in the Melton Road case, where under similar lack of 5-year housing land supply circumstances, officers consider the policy did restrict the supply of housing and afforded the breach of the policy only moderate weight. Ms Smedley's evidence is that because that policy, the ALS policy, needs review, then only limited weight should be afforded to CS11. Too many S's and L's in this case, I'm afraid, sir. In any event, Mr Cook's evidence is the proposed development would in fact maintain and respect the separation between Sileby and Cossington, with significant green infrastructure provided, including the creation of new enclosures as part of the historic landscape restoration scheme. The green infrastructure will be far more in keeping with the local rural farmland, with new wildflower meadows and pastoral fields, together with new woodlands, water features, improved recreational opportunities, to be read as part of the countryside, similar to that to the west of Cossington Road. Upon establishment of the landscaping, this would further reinforce a sense of physical and visual separation to Cossington. Mr Cook's evidence concludes that the physical and perceptual separation of the two settlements would continue and prevail with the scheme in place, as the development would not cause any actual coalescence. So whilst we say that CS11 is out of date, Mr Cook's evidence demonstrates compliance with it anyway. And similar to CS11, sir, G2 of the neighbourhood plan seeks to reinforce local distinctiveness, but goes on to list a whole number of other design-related criteria, which are specific detail matters which patently would be resolved through reserved maths application and therefore are of negligible concern in relation to an outline appeal. As design principles policy, it's consistent with NPPF, and of course we accept full weights afforded to it in that regard. However, in terms of local distinctiveness, dwellings to the north and west of the appeal site are undistinguished and architecturally reflective of the period in which they were built. The existing street scene is not considered to be of any specific local value, and delivery of new housing would not have a negative impact upon valued local vernacular. So the indicative layout demonstrates an appropriate scheme set against the existing character, density and urban grain of the settlement, therefore. Moreover, through design, it's possible to improve the southern settlement edge of Sileby through the delivery of outward-looking high-quality development. The current settlement edge, particularly the east of Cossington Road, is an obviously negative factor of the settlement in this location, with the rear of existing housing and fencing currently defining the settlement edge. Ms Smedley's evidence is therefore that the proposed development represents a scheme in broad compliance with Neighbourhood Plan Policy G2. I then take you down the cul-de-sac, the forensic cul-de-sac of valued landscape. So the argument that the site is a valued landscape has seemingly come out of nowhere, having first been introduced in the evidence of Mr Hickson. It's difficult to see how this was not an exercise in attempting to strengthen an otherwise deeply unconvincing argument. Officers and the LVIA authors do not share Mr Hickson's view that the site is a valued landscape, nor does Mr Cook. Mr Hickson is the outlier in adopting this position, and even the reason for refusal isn't with him on this point. As Mr Cook notes, the Guidelines for Landscape and Visual Impact Assessment version 3 provides box 5 a methodology to assess valued landscape. Mr Cook has assessed the site against all of those factors and come to a rounded view that the field is not a valued landscape in accordance with NPPF. He's also assessed the site against the criteria in the technical guidance note and again reaches the same conclusion. The worst point, frankly, for this rather daft foray on the part of Mr Hickson is that strategic planning policy objectives such as gap policies, are expressly not part of the consideration of whether landscape comprises valued landscape. When one reads TGN 0221 properly, even in the table that my learned friend took Mr. Cook to, it expressly supports the opposite conclusion to Mr. Higson, that purely planning designations don't warrant landscape being characterised as valued. This was in truth a somewhat desperate point which would not have been made if the council's case had been otherwise compelling. Indeed, it will be remembered that having been instructed, not only did Mr. Higson expand the council's case to allege that the appeals site comprised valued landscape, but he also expressly appeared to abandon the council's own assessment by LUC in 2021, which assessed the landscape sensitivity of this site as low medium. So if I can just deviate for one moment. So I invite you to contrast that with the point that my learned friend makes at paragraph 21 about Mr. Cook's view, where he says Mr. Cook takes one view about the consequence of the appeal being allowed, but Mr. Higson stands shoulder to shoulder with Mr. Golby, the author of the Golby and Look report. So with respect, when you read the Golby and Look report, as you will have done no doubt already, Mr. Higson's analysis and Mr. Golby's analysis are a world apart. And so whilst it's right to say that Mr. Cook has reached a different overall conclusion, he's done so by balancing positive and negative factors, which are the same ones identified by Mr. Golby. The true outlier in this case, sir, is Mr. Higson for the reasons I've just read out.
Thank you, I've noted that.
Thank you, sir. So overall, reason for refusal number 1 is not well founded. The purpose, integrity and integrity of the area of local separation is essentially retained. The physically narrowest point of the gap would remain unchanged. The perceived sense of separation would not materially change with the proposed scheme in place, and the establishment and maturity of the naturalistic parkland area would increase the perceived sense of separation over time, especially when considered from Cossington Road and the public right-of-way network. The proposed scheme would bring about a change in the character of the site, including residential and multifunctional green infrastructure, which would reinforce those characteristic elements of the local landscape. There would be no change to the villages of Sileby and Cossington were the appeal scheme to be granted permission. It would not cause a merging of the villages. Reason for refusal 1, sir, cites conflict with CS1 and alleges that further growth at Cossington will be disproportionate with the levels of development planned for in the core strategy. Well, sir, just to deal with that small point, which doesn't arise from the reason for refusal, as Miss Smedley explained in her examination in chief, that's just not a credible proposition. An obvious point which bears repeating is that CS1 does not impose a cap on housing numbers within service centres. The figure is not a maximum, nor does it provide a breakdown of growth to each of the individual areas of each individual service centre. So during the preparation of the core strategy, you'll recall you were told yesterday, delivery had already exceeded the figure set out in CS1 well in advance of its adoption in 2015. The policy, sir, was prepared in the context of that exceedance, and it was open to plan makers to have changed that approach on the basis of the figure, but they didn't do so. So it's quite wrong now to suggest that the fact that delivery exceeds supply justifies a different approach, as that would actually be at odds with the strategy that sits behind the plan. So paragraph 35, the fact that service villages have taken up some of the slack of the gross underperformance of the SUEs adjacent to higher tier settlements is frankly a matter of planning indifference, and certainly doesn't warrant the conclusion that there is a tension with CS1. Indeed, were it to be the case that there was a reason to conclude that Sileby had accommodated disproportionate growth, then no doubt that would not only have been referenced in the reason for refusal, but it would not now be proposed to accommodate a further 335 units in the emerging local plan. The point goes nowhere, and there is no rational basis to conclude that there's a conflict with CS1 in this regard, let alone a tension with a strategy where the main components have failed to deliver. So I was going to deviate from text, but I don't think I need to in the light of a couple of observations I've made already. So paragraph 36, settlement hierarchy paper, it's core document 611, acknowledges that whilst the same hierarchy tier, within the same hierarchy tier, Barrow-upon-Soar, Mount Sorrel and Rothley are less sustainable settlements than Sileby. That was the exercise Mr. Smedley took you to yesterday, sir. It's both reasonable and proportionate to conclude that more growth could and should be delivered in Sileby than the less sustainable settlements within the same tier. Further, Ms. Smedley's evidence is that Sileby is entirely suitable and capable of additional residential growth. That's a view that's shared by the council as the emerging local plan seeks to direct about 2,000. Well, I've said approximately. I'm not sure why the word approximately is still there. Delete that, please, sir. As the emerging local plan seeks to direct 2,747 dwellings to service centres, including, so that should be 335 to Sileby. The council thus continues to accept that Sileby is a suitable location for additional homes. Additional dwellings in Sileby would not be excessive or disproportionate. Consequently, Ms. Smedley concludes that there is no conflict with policy CS1. And in the alternative, sir, if you were to take the, if contrary to our case, you were minded to attach weight and conclude there was conflict with CS1, then of course only limited weight should be afforded to such conflict, as it's clearly out of date for all the reasons that we set out before. So reason for refusal number 2, contributions. So it's agreed with the council that this reason for refusal is now resolved. So the 10-year split of 51 affordable housing accords with the SPD of the council, and the following split set out in the draft conditions and the 106 delivers 77% rental, 23% shared ownership. And accordingly, the proposed development makes adequate provision for affordable housing. The proposal's effect on biodiversity would be satisfactorily addressed by detailed measures secured by condition and approved as part of the detailed reserve mass application. The proposed development makes adequate provision in respect to biodiversity and ecology. The on-site space, public open space provision and its management and maintenance is secured through the 106 agreement. So the officer's report considers overall that the development would provide good quality open space above the level required for the quantum of development proposed. And so obviously conditions related to the access and sustainable travel are included and include the provision of a travel plan to promote sustainable development. So the proposal is compliant with policy requirements in that regard. So I raised library and waste services about the 106. And so Mr. Gould, of course, accepted that covering open space, education, sustainable travel, waste and libraries, etc., overcomes the second reason for refusal by virtue of the 106. So there are also contributions towards improved football pitches in the Memorial Park and or enhanced pitches at the Cricket Club or Bowls Club, and towards the creation of community growing space or additional allotment plots at Memorial Park. Those are all included in section 106. And so I then turn to the contributions where there is a dispute. Firstly, sir, healthcare. So without adequate justification for the contribution, the appellant's position is there should be zero contribution towards healthcare provision for the reasons that are explained in full and in detail by Mr. Hunter and Ms. Smedley in writing, and which I only summarise in closing. Noting, sir, of course, that this fundamentally just goes to whether the blue pencil clause in the 106 is engaged and not whether or not permission should or should not be granted, as Mr. Richards rightly said as well. So a planning obligation, you will be aware, is only appropriate where it addresses those matters which are necessary to make the development acceptable in planning terms. It's firmly submitted a CCG contribution isn't necessary, as the NHS contribution means that it cannot be necessary for what's being sought. If a development is funding places whilst the NHS is also funding the same places, that's double funding. An expansion works by a GP practice, however, their funding can be reimbursed, as Mr. Hunter said, by a particular funding stream based upon rental value, creates the inherent risk of double funding. So a GP surgery's list is either open and accepting new patients, or is closed and not accepting new patients. The CCG confirmed that the lists of both surgeries are open, and therefore they can be assumed to have capacity for additional patients, absent clear evidence to the contrary. Capacity of Bank Surgery and Highgate Medical Centre could be improved by a number of measures, for example, longer operating hours, up to the standard 60-hour week. This is not a case where it's suggested that GPs stop working outside patient hours, as CCG rather oddly sought to infer yesterday in their documentation. Rather, the point is that the CCG just hasn't proven its case that there's a proper justification for matters that are not otherwise funded in order to secure capacity for patients generated by the development who are not already locally registered by a GP, as some of them will be. Importantly, this isn't a case where funding is being sought for a new site or funding for a new building in order to facilitate capacity being increased. Further, sir, we draw attention to the inspector's report, which Mr. Hunter makes reference to, and I give the reference at paragraph 47. So moving away from healthcare to education. So the parties agreed, it would seem, with respect to the 5 points set out in the education statement of common ground. And despite the forensic game of ping pong with the local education authority, the issues, sir, we think are somewhat clear on the basis of the evidence presented to you. The starting point is where there is sufficient capacity in the existing education landscape to accommodate new pupils generated by development, then a county council as local education authority is not entitled to education funding via a planning obligation. For all of the reasons explored in the education session, that is emphatically the case here. So the county's evidence establishes that planning obligations from Cossington Road are not necessary to make the development acceptable in planning terms. By way of overview of the two most contentious areas, i.e. primary school and secondary schools, the following is apparent following the exchange of evidence and discussions before you, sir. Sileby and Redlands Primary School and Highgate Community Primary School are not forecast to go over capacity. The county has confirmed that Cossington Primary School is being expanded by at least half a form of entry paid for by other developments. Similarly, secondary school infrastructure has not been proven before you, sir, as necessary to make the development acceptable in planning terms. The county hasn't demonstrated that there's a deficit of places at Humphrey Perkins School, or that the school will need to grow to accommodate pupils from this development. The county hasn't provided clear and unambiguous data confirming, so they have provided clear and unambiguous data confirming that there are 3 secondary schools with links to Sileby that should be considered to have appropriate capacity. So for all of the morass of information that's been presented to you on education, sir, and despite the recognition that we live in a time where public sector funding is stretched, the LEA simply hasn't discharged its evidential burden upon it to demonstrate that funding is warranted in this case to increase capacity at any stage of the education of children who will be generated by this development and who are not already in the local education system. So overview of the reasons for refusal, therefore. So the appeal should be allowed, you'll be unsurprised to hear me say. The reasons for refusal don't stand up to scrutiny. It's firmly submitted that even if harm is caused by the appeal scheme, that harm is decisively outweighed by the substantial public benefits, and so the appeal should be allowed. And so I then turn to the merits of the appeal scheme through the prism of the main issues. And I do so with a comparatively light touch, you'll be pleased to hear. So the first main issue is whether the proposed development will be in a suitable location, having regard to policy. So Ms Smedley broke that down into 2 questions: whether spatially Sileby is an appropriate location for residential growth, and secondly, whether there are any site-specific reasons to render the site unsuitable. So Ms Smedley noted that it's agreed that Sileby represents one of the most sustainable settlements in Charnwood and is appropriate for additional growth. It's also agreed that Sileby is identified as one of Sileby's 7 service centres. So I then set out what was read out yesterday as to what's in Sileby. I don't read that out unless you wish me to do so, sir. And so similarly, I also read out an extract from 4.19, or interpose that at paragraph 58 rather. So turning to paragraph 59, a non-exhaustive survey of Sileby's facilities and amenities therefore files that Sileby benefits from 2 primary schools, 2 preschool nurseries, several food shops, 2 doctors' surgeries, a dentist, opticians, vets, florists, hair and beauty salons, a gym, car garages, and many cafes, restaurants and takeaways. The community centre offers a range of activities, and there are numerous sports clubs, 2 allotment sites and the memorial park. So again, reference was made yesterday to the settlement hierarchy assessment, which assessed in that document Sileby as having 11 points, which is the same as Loughborough, Shepshed, Thurmaston and Birstall, i.e. the bigger urban areas. Unsurprisingly, given the list of facilities and services set out above, Sileby has far more than the minimum services and facilities required to designate a settlement as a service centre. Ms Smedley therefore considers that it's demonstrably a sustainable settlement suitable and capable for further residential growth. That's the only sensible conclusion that can be drawn from the evidence before you in my respectful submission. So as Ms Smedley explained in examination in chief, there's also a good level of public transport provision, including regular bus services to Loughborough and Leicester from within 100 metres of the site, operating what she said in her evidence is half-hourly services. We've not been able to confirm that what was said to you by the councillor yesterday. I think perhaps you might want to put a question on the half-hourly services, but so at the very least, hourly services during the day to Loughborough and Leicester, and hourly during the evenings, with journeys taking around half an hour in both directions. Sileby has a railway station which serves several villages on the middle and mainline route and main employment destinations throughout higher order centres. This offers access to a wide range of employment, recreational level leisure opportunities. It's of note that the remaining service centres, only Barrow-upon-Soar and Syston have a train station on the main line. Even Shepshed in the urban area does not have a railway station. Consequently, residents from the service centres of Mount Sorrel, Quorn and Rothley have to rely upon services provided at Sileby. Sileby not only provides for those living in the settlement, but also provides an important role for the wider area. In terms of site specifics, save for the response to the Council Landscape Officer, no objection was received to the appeal proposals from any other technical statutory consultee. And Ms Smedley has comprehensively addressed the third-party concerns in relation to the other areas that I've referenced above. So the landscape case, we say, isn't accepted for reasons I've already said and I won't repeat. So then there are therefore no site-specific reasons why the site is unsuitable for development. And in terms of sustainable travel, the scheme provides new bus stays, shelter, display cases, flagpole, as well as raised curbs to allow level support to modern bus fleets. The 106 also provides for 6-month bus passes and a travel pack for each dwelling to promote the use of sustainable modes of transport. Both the highly accessible bus and train services will provide future occupants of the development with a real alternative to the private car and help reduce traffic and congestion on local roads. So CS15 seeks to ensure adequate open space is provided. Well, we propose 5.888 hectares of new publicly open space across the site. 58% of the site comprises that open space, making provision for parks, natural and semi-natural open space, amenity green space, equipped play well in excess of the requirements, because those typologies, sir, would require only 1.18 hectares. That means that there's an over provision of 4.7 hectares of open space, which would seek to address the existing shortfalls in natural and semi-open natural space in Sileby, which should be seen as a benefit. So if I just deviate from text momentarily, of course, it would have been open to my client to have just promoted 1.818 hectares of open space and leave the southern part of the site untouched. They didn't do so, sir, because it enables the use of that land in the public interest and any requisite landscape changes to that land to reinforce the objective of securing separate identities. If there is one paragraph, sir, I'd wish to stress in this whole closing submission, that paragraph is the one. Paragraph 64.
Thank you.
Thank you, sir. The officer's report considers that overall development would provide good quality open space above the level required for the quantum of development proposed, therefore. So, of course, there's an acknowledgement that Safe Policy ST2 of the 2004 local plan restricts built development to within the limits of development. As Ms Smedley addressed in her proof, the limits of development in 2004 were to reflect the need from 1994, 28 years ago. That housing need at 556 dwellings per annum is half the current annual need of 1111 dwellings per annum. The current limits to development for the plan period commencing over 30 years ago are plainly not appropriate for meeting current housing needs and are therefore seriously out of date. It's unsurprising, therefore, the council have over time allowed breaches of policy ST2 by approving development beyond the defined limits, and indeed intend to allocate many sites beyond the current limits in the emerging plan. The council's granted permission for a number of housing schemes outside Sileby's development limits, including almost all of the development sites shown on ID4. Further, the council is relying upon land outside Sileby's limits to development to contribute towards the borough's 5-year housing land supply. Those limits cannot be up to date. ST2 is a policy for the supply of housing. It's out of date for all of those reasons, and only limited weight can be afforded to the policy conflict arising from development outside the limits of the development. And for the same point, Ms Sileby notes there is conflict with G1 of the Sileby Neighbourhood Plan, which seeks to restrict development on land outside the limits of development, resulting in a conflict. Well, so the Neighbourhood Plan was made over 2 years ago and has no unreserved housing allocations. Consequently, the provisions of paragraph 14 of NPPF aren't applicable. It's a policy for the supply of housing and necessarily, therefore, presumed to be out of date. And in common with ST2, only limited weight can be afforded to its policy conflict. So turning then to the overall planning balance. So policy CS1 sets the development requirements of Charnwood over the period 2011 to 2028, including at least just shy of 14,000 dwellings. CS1 sets out how the growth is to be delivered. But sitting here today, no dwellings, again, mentally underline those words, no dwellings have been delivered in any of the SUE locations, despite the core strategy trajectory anticipating that 2,245 dwellings would have been delivered there by now. It's agreed, sir, that the 2004 local plan and the 2015 core strategy are more than 5 years old, and the council is unable to demonstrate a 5-year land supply together with the appropriate buffer. The supply is, or at least it was until later on this afternoon, 3.34 years. It's less if category B sites are excluded, but 12 months further on, it's understood that the 5-year housing land supply position hasn't numerically improved and the SUEs still aren't delivering, with the latest position being a mere 3.23-year supply. So the emerging local plan, the 7th cavalry in my learned friend's closing submission, isn't an imminent solution, and certainly isn't as imminent as Mr. Gould would have one believe. The emerging local plan awaits full scrutiny through the examination process and is agreed to be afforded only limited weight. The evidence base is incomplete. There are substantial controversial issues to address, which goes to the heart of the emerging local plan strategy, and the issue of overcoming Leicester's overspill needs hasn't been grasped at all. This is not an everyday set of issues to resolve. This is a highly controversial local plan that will need careful scrutiny. And yet, without knowing much about it, and without knowing much about the principal controversial issues, Mr. Gould confidently asserted that adoption next summer would be achievable, before conceding after some time that such a day would be very much a best case. With respect, it may be achievable, but it's not very probable, and it's a matter of speculation when the emerging local plan will come to the rescue of the local planning authority, which continues to fail to meet the minimum requirements of government. So in cross-examination, my learned friend skillfully put to Miss Smedley that if things go to plan, then even with a hearing on main modifications, the plan could be adopted by the end of 2023, and fairly, she agreed this could happen. But it took re-examination to find out what level of confidence Miss Smedley had in such a prediction, i.e. that there is every prospect that things won't go to plan, and suggesting adoption by the end of 2023 is no better than speculation. To suggest that the appeal should be dismissed in part because one has downgraded the benefit of meeting an immediate need for more housing due to the prospects that things might get better by Q1 of 2024 is Micawber-esque. And sir, obviously I give you the footnote there because I'm sure that you're well read and you're aware of what Wilkins Micawber from Dickens, but it's the something will turn up point. So can I just expand upon that a little more, if I may? Because the contrast that was put in re-examination wasn't the direct contrast with Warwick or Cheshire East, etc., or the specific circumstances there. It was the contrast between a plan going correctly in terms of what one would expect and the wheels coming off an examination, something going wrong. and the something going wrong point isn't resolved by the standard method, because there's lots of reasons why a plan can go wrong. And sitting here today, we don't know if something will go wrong. There's literally no evidence before you, one way or the other. But, and to reference the forward planning elephant in the room, a local plan which starts out in its submission version already with a mechanism requiring an immediate review once the Leicester figures agreed, is not on a road where one can be optimistic about rapid adoption. The word controversy could have been made for forward planning in Leicestershire.
Thank you.
Thank you, sir. Paragraph 72. So the impact is upon the lives of real people in real housing need, and the only way to resolve the immediate need is by granting more permissions in sustainable locations, or, to use Mulliner Friend's words, to make the difficult and unpalatable decisions now. With respect, the council may have done so elsewhere, but more needs to be done. That's why they've got less than 5 years. If Mr. Cook is right in his assessment of the site, and it's firmly submitted that he is, then this is a sustainable and accessible site which can bring real benefits and should have been consented by the council last year. Against this background, it's agreed that the policies most important for determining the planning application, forgive me, it's not agreed, it's submitted that the policies most important for determining the planning application are out of date, and the presumption in favour of sustainable development is agreed to apply. So the harms arising from the appeal scheme are limited and nowhere near enough to outweigh the benefits of the scheme, let alone when the balance is tilted in accordance with paragraph 11 of MPPF. And the only identified harms of any real moment are the conflicts with policy, which are not acknowledged to be out of date and in need of review, and which shouldn't attract any more than limited weight. So the benefits of the scheme are, however, by contrast, considerable. And they are, sir, as set out at paragraph 830 of Ms. Smedley's evidence. So I'm going to just summarise the bullet points, if I may, rather than read them, because this is, I'm only ever a second-rate plagiarist, and these are very much taken from Ms. Smedley's evidence that she gave yesterday. The first of which is obviously delivery of market housing in a sustainable location when there isn't a 5-year housing land supply. The second of which, sir, is the delivery of affordable housing, which we invite you to conclude is acute. Firstly, because it's increasing, and you've got the references there that as each Schmar and Hedner has gone on in the 20 teens, it's being increasing from 180 up to our current figure, which is now, sir, 392, and then up to 476 within the current Charnwood Housing Needs Assessment. So it's gone up way beyond twofold. The next one, sir, is the extent of public open space, and I've already made submissions about that. Then the next, sir, is the additional contributions towards outdoor sports in Sileby. Yes, that's making provision for the needs of the residents, but plainly that funding would also have benefits for existing residents. Next, sir, economic benefits of the proposed development. Next, sir, the fact that the delivery would be in a sustainable location, which is really picking up points 6 and 7. Next, sir, environmental benefits of the new planting, which is extensive and better reflects the characteristics of the wider landscape. Next, sir, the delivery of the edge to the settlement, which will be an improved edge. And then, sir, the issue of biodiversity net gains. So as paragraph 76 then, sir, weighing harms against benefits, Ms. Smedley concludes the appeal scheme accords with the up-to-date development plan, with conflicts arising only against policies which are out of date, we say, or for which only limited weight should be afforded. In any event, the tilted balance is engaged and the limited harm arising from the granting of permission simply does not significantly and demonstrably outweigh the benefits of the appeal scheme, and permission should be granted. In conclusion, in favour of the appeal scheme are significant public benefits which demonstrably outweigh harm asserted by other parties, the scheme complies with the development plan and should be approved without delay. But if not, the balance, tilted or not, is clearly in favour of granting consent for the sustainable scheme, and it's firmly submitted that that should be the outcome of the appeal scheme. So unless I can assist you further, those are my submissions in closing.
Thank you, Mr. Tucker. I just have one point of clarification, which I think I've worked it out, but just in paragraph 11, there's reference to the public open space for Clarendon Road and Humble Lane. And initially was puzzled by Clarendon Road, but I think the land itself is promoted by Clarendon Homes.
That's exactly right, sir, yes.
So we're not talking about two sites there, we're talking about the same site.
We are absolutely talking about the same site, sir.
Fine. I thought that was the case.
Just as, sir, I had the pleasure of advising on a site in Essex at a place called Cossington after we'd finished yesterday. And that's, I think, why I slipped into describing Cossington as Cressington at one point during discussions yesterday. So apologies for that mental slip on my part, sir.
That's easy done. Just wanted to clarify that in paragraph 11. So thank you.
Thank you, sir.
Thank you. I don't have any other points of clarification. So that brings the appellant's closing submissions to a close. And then really now it's just a question of wrapping things up before we close the inquiry. So yesterday, both parties indicated that they weren't intending to submit cost applications. I assume that's still the case. So we don't have to get through that. Yep. Thank you, both nodding. So that's fine. So in terms of anything outstanding, we have the only one outstanding document is the 106, the completed executed 106, and we've agreed that that would be submitted in PDF form by the 13th of May. So I'm assuming that's still the deadline, that's still achievable, and I'm sure parties will let me know if there's any issues with that if they come to light. And then I was just clicking during the break. I clicked on the link to ID 23. It now seems to be opening for the appeal decision. So I think that the password protection thing has been amended, and I think all other documents are on the website. And yes, I just want to say, obviously, if the council can keep the website live for now, Mr. Richards, is helpful in case of any sort of need to refer to things.
Yes, and I think the intention will be to keep it live for at least 6 weeks after your decision is issued, for obvious reasons.
Yes, fine.
But I don't think the planning inspectorate customarily directs when it should be taken down or could be taken down. But that's our intention.
Okay, that's fine. I mean, it's ultimately it's a decision for the council. It's only my advice that it be kept live for that period. So that's helpful if that can be done. Thank you. I should say thank you to the council for hosting the documents on their website. It has been very helpful and useful to sort of find things there, and hopefully has assisted others too. Are there any sort of final procedural queries from anybody before we adjourn? Anything from Mr. Tucker from the appellant?
No, sir. Safe to associate my team's comments with yours about the extreme usefulness of the approach that's been taken by the council in relation to both hosting this session and also the documentation. Those behind the scenes have been helping with technical issues in terms of people joining, etc., and have been extremely responsive, and that's more than welcome. And in terms of the core document page, it's certainly well up there in terms of the better ones, and that makes everybody's life a lot easier and the inquiry runs smoothly. So whoever is responsible for all the hard work behind the scenes, behind my learned friend in inverted commas, then certainly we would wish to pass on our thanks as well.
Thank you, Mr. Tucker. But that's good to know. And yes, I'll certainly also thank the council for hosting the event and doing the live streaming as well. That has been very helpful. Thank you. Nothing else, Mr. Tucker, for the event.
No, sir. I've already thanked you for the leeway which was shown to half my team falling ill during the early parts of the inquiry. So I repeat that as well, obviously. Yeah.
Well, I'm glad we've managed to get through to the end now. So that's good.
Yes, sir.
Thank you. Mr. Richards, anything else from you?
No, we thank the appellants team for the what I hope is obvious cooperation between the two main parties that there's been behind the scenes at this inquiry. And also, I would like to thank the parish council representatives and the other members of the public who took part. It's always dispiriting as an advocate when there is nobody from the local community either wanting to speak or ask questions. And so I think it's been a very good thing that the parish council and the neighbourhood plan team at Sileby have contributed in the way they have.
Yes, I would agree with that, and certainly it's been very helpful to hear from local residents and the parish council throughout the inquiry, and it's certainly been very useful to me in my deliberations to come. Thank you. Anything else, Mr. Richards?
No, thank you very much, sir.
Thank you. Is there anything from anybody else? Any final questions or queries that anybody would like to raise? Just in case anyone's wondering, my decision will be issued as soon as possible. Obviously, we say that at the end of every event. I won't set myself a deadline as I'll be setting myself up to fail, but the decision will come out as soon as possible, and obviously will be circulated to both main parties and will be made aware to interested parties too. And so obviously that will follow in due course. So if there's nothing else from anybody, then I'll just thank everyone again for their input and contributions and cooperation during this inquiry. And that's probably all I need to say, and we'll end things there. So thank you all again, and the inquiry is now closed.
Thank you, sir.
Goodbye.
Thank you, sir.